And everyone. Tonight, as I said from my intro, I'm going to have interaction with our viewers, and we have quite a unique topic for tonight. Last week, we looked at employment law. Tonight, we are going to look at immigration. So I'll be looking at visas. People who have visas, indefinite leave to remain, student visas, skilled workers visas, visit visas, all kinds of visas. I'm going to look at the grounds on which those visas sometimes can be cancelled. And I will look at the legislative powers of immigration officers and how they can enforce those powers on arrival. Say, for example, one is coming from abroad and it gets to arrival. The entrenched powers that officers have to enforce, to the extent that sometimes they can detain, they can revoke leave, and the grounds upon which those decisions can be taken. So I'm not going to take much of your time tonight because at the end of the show I'm going to allow viewers to ask questions. But obviously I want to entreat you to share the video with your friends, because I know that immigration is life. If it doesn't affect you, it might affect one of your friends, it might affect a family member, it might even affect your girlfriend. So most times, some of these things might not concern us individually, but obviously there are people around us that may have some of these issues or may have to learn tonight so that they can obviously protect themselves and not fall victim of having their leave revoked, curtailed, or cancelled. So tonight, that is what I'm going to do tonight under the immigration laws. So to start with, obviously, as I do always, I'm going to give viewers the opportunity to get themselves ready for the topic. I'll go on short commercial break, and when I come back, straight away, I'll be discussing the topic for tonight. And as I said from the beginning, it's going to be quite short. However, I will give viewers opportunity to ask questions. So I want you to be patient with me as I go on this short commercial break as we advertise our sponsor. It's an opportunity for you to also look at the screen to see the areas that we cover. It's not just immigration. And that is what I want you to do when I go on this short commercial break. So please, don't go away. thank you so much for your patience. As I said from the beginning, I'm going to make this topic quite succinct, but it's important that we learn something tonight. I always say that whenever I come to this studio, I discuss very topical areas of the law, topics or issues that are quite prevalent, and therefore I take up the opportunity to educate viewers on their right. And tonight I am here to look at visa. When you have a visa, for example, if you have been fortunate to be granted a visa from abroad and you are coming into the UK, whether you can be refused entry, or for example, even if you have a visa or a permit that has been granted in country, I mean, you lived here, you made successful application, that application has been successful, so you'll be granted that leave. Can that leave ever be cancelled? And if it is that it can be cancelled, on what grounds? What are the powers of the immigration officers who may intend, one reason or the other, to revoke, to curtail, to cancel, to refuse entry? That is what I'm going to look at tonight. And I know that this is a very sensitive area of the law, in the sense that most times when people are coming in and they get to the border or on the point of arrival, a whole lot of stuff happen. And sometimes it is quite pathetic because people are just coming to this country for the first time and they are very unfamiliar with some of these powers, because sometimes when people get visas, they feel that obviously when you have a visa, it allows you entry to a place. Little do they know that that entry sometimes can be refused, and it's sometimes quite baffling. But people can avoid some of these disappointment if they prepare, if they understand the conditions of that visa or that entry permit or that leave to remain. Because most times when you don't know condition of something that is in your possession, then obviously you can be in breach of that thing that you have in your possession. So just like visas, as any other thing, they also have conditions. And it's for that reason that people need to understand some of these things surrounding those visas. Because sometimes people even have visas and they don't know the requirements that they need to abide by in order to sustain or to maintain those visas. Or sometimes people are coming to school from abroad, especially we are going to enter in September very soon. Most students are going to be granted visas and they will be coming to the UK to study. And most times when they get to the point of entry, there are challenges. Tonight, I'm taking this opportunity to give you free legal advice. And my advice is going to fall in categories, because there are various categories of visas. So tonight I'm going to look at almost about 4 categories of visas. And these are the common passengers. These are people that normally get stopped, detained, either refuse entry, either granted bail, either have their leaves curtailed, revoked, or cancelled. So tonight, I'm going to start with people, ordinary visitors who, for example, are coming to the UK. Now, why it's so important that people who are coming on visit needs to be mindful of the conditions that are abide by their visas. I always say that when you have a visit visa and you are coming to the UK, most times when visas are granted, they are granted in the light of looking at one's socio-economic circumstances, which is the fact that what are you doing back home? What is it that will persuade or will convince the entry clearance officer who is giving you the visa that there is an incentive to return, which means that there is something, a pulling factor, something that makes it quite encouraging for you to go back. So most times when people are even refused, they normally will mention, we have looked at your socio-economic circumstances. What that simply means is that they are looking at everything around, financially, cultural, whether you are well settled with a family, what role are you playing in a community. So they look at all these factors before these visas are granted. But when the visas are granted, remember that, for example, when you are applying for visit visa under the Appendix V, you have to satisfy the requirements that will enable the entry clearance officer to grant you visa. Then when you are coming in, you need to also satisfy what they call entry requirements. So it means that sometimes you may have a valid visa as a visitor, but you could be refused entry. So it means whenever you are coming in as a visitor, you need to understand that getting the visa is not automatic entry. You could be stopped. But most times when people are stopped, they don't even know the conditions of their visas. They don't know how these forms were completed, whether there are questions that reasonably they expect them to know. And sometimes they are refused entry on the basis that because there is contradicting information, that they feel that false information has been provided in support of the application. And some of these people sadly are refused entry, their visas are revoked, and sometimes they are removed. So I'm using quite strong terminologies here. So I've said that entry is refused, visa is cancelled, or removed. And if you are fortunate, you are granted what you call a bail, or what used to be temporary admission. And eventually, as a visitor, you don't have the right to appeal, but you can make administrative review. So that's the category of those people who are coming with visitors who can be refused entry, and these three things can happen. Now let's look at students, those who are coming in as students. Now we know that we are in August, and obviously by September this academic calendar will commence. Now I always say that as a student, if you are coming in for your course, you've been granted visa, and I know that you have perhaps even met the financial requirements. However, sometimes due to financial challenges, one may decide that he wants to delay and to raise some funds before they finally come in to pursue their academic courses. But the danger here is that any student that is coming 28 days after the commencement of the academic program is more likely to be stopped, to be detained, and possibly that visa to be cancelled, removed, or to be granted bail. Why? Because if you are coming more than 28 days before the commencement of your course, it's enshrined in the immigration rules that caseworkers or immigration officers have powers under those circumstances to conduct further examination, which means that sometimes they may have to contact your school. And if the school cannot confirm that you will be eligible to join and continue the program with the existing students, then you could be removed. But if you are fortunate, you might have your papers retained and granted bail, pending you sometimes making an administrative review. Okay. But more importantly, sometimes when you get to the point of entry, if you are coming with dependents, they expect your relationship to be genuine. So they expect you guys to know common things about yourself. And in a case where, for example, forms have been completed where you have no knowledge what information have been provided, and I say that being granted a visa is one thing, being granted entry is another. The two are mutually exclusive and quite distinct in nature and are bounded by different requirements. So one may be fortunate to be granted that visa as a student, but obviously at the point of entry, one may encounter some challenges. For example, caseworkers or immigration officers have powers under the Immigration Act to conduct examination. So sometimes they might examine your documents that were relied upon to submit the application upon which you'll be granted this leave. And sometimes you could also be interviewed about the course. So when people are coming in, they need to understand that some of these challenges may come their way, and they should be well prepared before they come in. Because sometimes people, for example, get people to assist them. Of course, lawyers, we assist people to make application, but obviously we also give them advice. Sometimes you may have a family member who may assist you, and sometimes people don't even question or query what information has been recorded for them. And most times when information that has been entered on their behalf and they get to the point of entry and they are not able to give consistent account, the word here is consistent, which means that when there are contradictory accounts, then it's more likely for the immigration officer to sometimes conclude that false information has been submitted in support of your application. And the danger here is that whether knowingly or unknowingly that information has been submitted, the caseworker can rely on under paragraph 341 of the immigration rules to cancel your leave. So that is the danger that people need to be prepared for, and they shouldn't just come in as celebrants because of the fact that they've been granted student visas to come and pursue a program. So I have looked at those who may have the danger of getting their leave cancelled or entry refused as visitors, those who are students. Now at this point, I'm going to also look at, currently, we also have large amount of people who are coming in as skilled workers. Now, we have this large amount of people coming in as skilled workers because I said that the beginning of last year, which is around January, we had almost 250,000 shortage in the healthcare sector. And as I speak to you now, there is an immense shortage in this area. And because of that, the government, in its own wisdom, has given opportunity for skilled workers to come into this country. And I'll tell you this. Let me tell you why there is high demand of skilled workers. Because if you look at the current immigration rules, we are no longer in the European Union, and therefore free movement of European citizens has stopped, except those who are coming in as joining family members, or those whose relationship have existed before December 2020, who are now able to make application to come in, relying on the Appendix EU of the immigration rules. So you realize that if somebody is coming from Spain, Italy, Germany, as a skilled worker, that person will have the challenge of not being able to sometimes meet the English language requirement. And it is for this reason that there is a high shortage of skilled workers in various sectors of the economy. But it's quite dire in the healthcare sector. And it is for this reason that most of you are getting the skilled worker visas to come to the UK, because of the shortage of occupation, which has been caused by our exit from the European Union, thereby stopping free movement of EU citizens and their family members. But having said that, when you have a skilled worker visa, either as a dependent or as a main applicant, and you are coming into the UK, there are other things that you also have to be familiar with. Again, if your employer has given you an offer of employment and you are coming in with that offer letter in your bag and you are more than 28 days late to start or to commence your employment, then at this point, the the immigration officer may exercise powers to revoke your leave. So these are common stuff that people can avoid. But the other point is that, which has come to light most often, is the fact that if you are coming with dependents, then you should be familiar with most of your information concerning yourself. But more importantly, I have in practice witnessed cases where there are minor mistakes where case workers have overlooked it in terms of the satisfaction of the requirements. And then when people are coming in, after being detained, further examination being conducted, it's been discovered that some of the requirements are not met. So my advice to you is that whenever you are making most of these applications, you need to ensure that those requirements as laid out in the immigration rules are satisfied. Because sometimes when they are not satisfied, you might be fortunate because of the mistake of a caseworker to be granted a visa, but you could be refused entry. So that is the category of those who are coming in as skilled workers. I am coming to the last section, which is EU family members. So I have discussed 3 categories of visas. Now I have explained how some of these visas can be cancelled on the point of entry, how some people can be removed, how people sometimes can be fortunate to get a bill, but their leave may be curtailed, cancelled, revoked. And I'm gradually coming to the last category of people, which is EU citizens and their family members. But before I do that, I want to acknowledge those of you who are on this platform tonight, who are enjoying the show and participating with the program. So if you are watching me and you want me to acknowledge you, I urge you to put a comment so that I will be able to acknowledge your presence. It's important that you are acknowledged. So if I'm right, I can see that I have Yellow Man, which is Abubakar Ali Asalitu, who is watching tonight. I have Amaka Martins. Well, this is somebody that I have not seen before. My regards to you, Amaka Martins, who is watching tonight. I have Sophia Asong, who is a regular member of the show, who has been joining us every now and then whenever we are here for this show. He's a good evening lawyer. Good evening, Sophia Asong. I have Trudu Mansa Bonsu, who is also watching tonight. I have Jeremy, who is the best lawyer of all time. Much appreciated for your service. May Allah guide you abundantly. Inshallah. May Allah be with you too. I have Desmond Benia, who is also a regular member of this show, who is also watching. Ernestina Kerry. He's a good evening lawyer. Ernestina is also watching tonight. I have Justice Peace, who is also watching. Justice, thank you so much for joining us today. I have Kweku Tanoku, who is also watching. I have Fitnat Bodi Majub. Wow, I'm trying hard to pronounce your name. Please forgive me. Fitnat Bedui Majud. Thank you so much for joining us tonight. I have Gideon. Wow, Gideon, it's been a long time. Welcome back. I have Samuel Apia, who is watching tonight. I have Desmond, who is watching you live. Thanks, lawyer, for the good job. I have highly favored Priscilla, who is also watching. I have Tina Tamakru. It's a good job, sir. Tamakru watching all the way from Ghana. I have Joe Chaka, my own MC, who is the host of this show, watching tonight. I have Justice Peace, who says that fantastic one, bro. Well done. Very educative. Right. So, guys, it's been amazing. It's always a privilege to have you guys, for us to have some of these interactions, to protect our community. I'm always thrilled to be here to bring you good tidings and to give you education, fluently sponsored by CITI Law Solicitors, so that you can protect what God has given to you. So tonight, I have looked at these three categories of visa categories of people who may be granted leave or visas in these categories. I am looking at the last section of those people who are so close to my heart, which is the EU family members or the EU citizens themselves. Now, there are two categories of EU family members. There are those who are coming in as with family permit, and there are those who have been granted leave to remain, as EU family members. And of course, for the past week, when we had our last show, we discussed how people can retain their rights. We've also looked at domestic abuse, which allows people, even who have been in their relationship for less than 3 years, to also retain their rights. If their relationship breaks down irretrievably. But it's also not uncommon that people are getting stopped and being refused entry or getting their leaves revoked for various reasons. So tonight I'm just going to look at some sections of the law and the powers that immigration officers have, and whether or not in some circumstances they have exercised these powers correctly, and how people can understand their right in terms of the fact that if they are coming from abroad and they are encountered and they are being detained for further examination. The starting point is that if you look at Annex 3 of the Appendix EU, there are powers for the Secretary of State to revoke a leave that has been granted under the Appendix EU of the immigration rules. And this is enshrined in Annex 3 of the Appendix EU. And those powers can be exercised in almost 3 areas. But sometimes I looked at some of these decisions where people's leave have been revoked under certain grounds, and then I asked myself whether those grounds are valid, because the rules have specified grounds which allows immigration officers to revoke leave. And most times when I'm doing this sense, I always try to give a background of the EU law. And then eventually I'm able to explain to viewers why they must not allow certain things to happen to them. They must know their right, especially when the old law, which is now obsolete, is being applied to them. So I always said that under the European regulations 2016, there was this regulation 6 and regulation 3, which clearly borders on the fact that one needed to have been a qualified person as EU national, which means that either working, either self-employed, or a student with private medical insurance, or self-sufficient. These 4 categories of people were able to bring their family members to the UK. They were able to maintain them so that they could continue to live here as long as they were here. But if you look at the regulation 3 of the old law, if one was not here continuously for 6 months, which is not exercising treaty right, either not working, either not being self-employed, either not being a student with private medical insurance, or not being self-sufficient, then that person right to exercise treaty right has ceased. They call it cessation of treaty right. So when it ceases, it gives what they call a break. So under those circumstances, if you're a family member and you are coming in and your family member have ceased to exercise that right because they have not been working continuously for 6 months, or they were not in this country, then you could be questioned and subsequently be detained and removed on the basis that you didn't have the right to come to the UK anymore because your EU family member, who is your main sponsor, has ceased to exercise treaty right or has left the UK. So under those circumstances, it was quite common for people to be stopped, for people to be detained, for people to be removed, and if possible, sometimes granted bail. I want viewers to take note of this quite carefully. Now, so having explained the old law, which allowed immigration officers to exercise some of these powers, let's look at the new law. Now, under the Appendix EU, which have superseded the EU Regulation 2016 as amended, the grounds for stopping someone, the grounds for revoking leave has changed. Now, again, under Regulation 23 of the old law, apart from one having ceased to exercise treaty right as a family member, there were other grounds for people to also have their leave revoked. And this even included EU family members, EU citizens themselves, not just their third country family members. When I say third country family members, I mean Ghanaians who are either married to EU nationals, Nigerians, Ivorians, Americans, any other person other than EU person who is married to an EU or who is a family member by virtue of a relationship with another EU citizen. So within this regulation, you've realized that leaves could only revoke, apart from what I've explained in Regulation 3, by cessation of one's treaty right. But there were other grounds that leaves could also be revoked. And those were if one poses public security risks. So you pose a risk to the public in terms of security, then, for example, if you are one of those people who want to throw bomb on the street, then of course your leave, you pose security risks. So you can see that the threshold is quite high. Your leave could be revoked, or that family member leave could be revoked. Or if you pose a risk in terms of medical hazard, then of course, again, under medical conditions, your leave could also be revoked. So, apart from these grounds, then it is quite difficult for one's leave to be revoked under the old law. But some of these laws have been transposed into the new law. But the distinction here, which is where I want viewers to take note of the fact that under the Appendix EU, you will find out that there have been some addition of grounds that allows immigration officers to revoke leave. This time, not because their family members are no longer working. So it is quite invalid for one to revoke a leave on the basis that another person's family member is not working in the UK, because that is not established in law anymore. However, if, for example, it is established that forged documents knowingly provided in support of an application, then once one is coming in and is detained and examined, the immigration officer has the right to revoke a leave or cancel or curtail and remove or grant bail. Or whether false information or documents were provided unknowingly is not an excuse. Again, second point, that could also give grounds or powers for the immigration officer to revoke leave. And finally, if it's established that one's relationship is that of a sham or not genuine, then there is also a power to revoke that leave. But the distinction here is that when it comes to establishing genuine or sham relationship, the burden is on the Secretary of State. So you find out that is why most of you, when you are coming back from your holidays, you get stopped and interviewed, because that interview is to extract information from you for the immigration officer to rely on it to say that your relationship is not genuine, so that they can revoke your leave. And therefore, if you are not with your partner, you need to be prepared that some of these things may come to light, and these challenges may be posed to you on arrival. And if you are not able to explain yourself quite frequently or adequately, then your leave is more likely to be revoked. So you now understand why most people are now being subjected to a lot of interviews on the point of entry. It is because of this reason. But having said that, once in a while I was so appalled that somebody was coming in, detained and subjected to an interview, and eventually a decision made to revoke, and he was forced to sign a document so that he could be removed voluntarily. I want to tell you this. Whenever there is a decision at the border, you have three rights. You have right not to be detained longer than is necessary by law. You have a right to have a bail if your leave is curtailed or revoked. Thirdly, you have a right to appeal that decision. That is a right that you need to exercise by law. And you have a right to administrative review, where you make submission for that decision to be reviewed. But the point is that immigration officers at the entry or at the border have limited powers in revoking some of this leave. Why? Because after further examination, for any leave to be revoked, they need to refer the case to status review unit. This is where I want viewers to be quite attentive. It means that your leave cannot simply be revoked. Before your leave is revoked, that officer needs to have good reason and be able to make a case such that that case can be referred to the status review unit, which is the unit that has the power, the ultimate power, to make a decision on either to revoke your leave or to maintain that leave. So how you conduct yourself at the point of entry matters, and the information gathering stage is so essential to determine whether that immigration officer referring your case to the status review unit or not. And when the case is referred to the status review unit, it is at this point that the decision, the ultimate decision to revoke your leave occurs. And I have already pointed out that once this leave is revoked, one is entitled to appeal. Anybody, I'll tell you what, 3 things happens. When I was making my submission, I said that if false information is supplied or provided in support of one's application and it's come to light, that leave can be revoked. If it's established that the relationship is not genuine or has broken down, that leave could be revoked. But when a leave is revoked in country, where, for example, you are in your house and they write to you that there is a decision to revoke your leave, you have 2 rights. You only have a right to appeal that decision. However, when one has traveled abroad with the same leave to remain or pre-settled status and is coming from abroad and it gets to the border and there is a decision to revoke that leave, he has 2 rights. 1, to appeal that decision, and 2, to make application for administrative review, which is quite distinct, because those of you who receive letters through the post, you would not, as under the Appendix EU of the immigration, you will not have the right to administrative review. So you find out that those who are at the border, who get their leave revoked at the border, will always have these 2 rights. Right to administrative review and right to appeal. So tell me, if you have these 2 rights, why then do you get automatically removed? And there are a lot of people, myself, I had a client who was just scamming as a spouse, eventually got detained, and before we could even make submission to get her bail, she's been removed because she was forced to sign documents to return. I want to advise viewers that you have these 2 rights, and therefore whenever you encounter such a situation, you need to ensure that you exercise that right to appeal or to administrative review, rather than being removed automatically without exercising that right. So tonight, it's been an opportunity for us to discuss the grounds and the powers that immigration officers have to cancel the leave. At this point, I'm going to open phone lines if anyone has questions to ask, whether about this topic that I have discussed tonight, or whether about general immigration question, whether it's about employment law, any legal question that falls within my jurisdiction, my competence, and my areas of practice, I am going to give you that free legal advice. I always say that I am not a doctor to give you diagnosis. I'm not a pharmacist to give you prescription. I am not a counselor to give you counseling about your relationship, but I know the law. So I'm here tonight, well prepared to answer your legal questions. This is your opportunity to get free legal advice. So at this point, I'm going to open the phone lines, and then what I normally do best is to advertise CITI Law Solicitors, because CITI Law Solicitors is the one that is sponsoring this program tonight. So the phone lines are on the screen. If you want to ask any legal question, the phone lines are 0793 29 34 518. 0793 29 34 518. Alternatively, there is a second studio number 0744 033 8623. 0744 033 8623. That is the second studio number. If you have any legal question, this is your opportunity for free legal advice. Whilst waiting for anyone who wants to ask any question tonight about what we've discussed tonight, I'm going to advertise our sponsor. The sponsor for this legal hour show is CITI Law Solicitors. CITI Law Solicitors specialize in numerous areas of law. If you want to look for us, you can find us at Barking, Unit 113 or 122, Barking Enterprise Center, 50 Cambridge Road, Barking, IG 11 8FG. If you want to come to visit us and you want to come by train, you can come by the district line to Barking. You can come by the C2C line, which also goes through Barking. And once you come out of the station, you turn right. And as soon as you come out of the station, you will find some very beautiful KFC there. It's a joint where you can have some chicken if you're hungry. And then eventually, once you come out, you turn right again on the zebra crossing. And straight, in 2 minutes, you get to Barking Enterprise Center. That is where you find CITI Law Solicitors. If you want our phone number, those of you who want to come by bus, you can come to from Romford. The bus 5 goes there, 232, or the buses through that Cambridge route, where you can find us there, so you won't miss your way. However, if you want to call us, our office telephone number is 020 33 55 0782. I repeat, 020 33 55 0782. This number is also on the screen, which is the scrolling text on the Facebook page. You can also get the number from there. Now, we specialize in these areas of law. We specialize in immigration, which is our foremost area of practice, and that is what I've been discussing tonight. So if you have any immigration matter and you want us to assist you with, you can come to us and we'll be very happy to assist you. We also specialize in employment law. If you have been dismissed unfairly, last week I had last week I had the opportunity to discuss the Equality Act. I made a promise that I'm going to look at the various protected characteristics under the Equality Act 2010. Last week I had the opportunity to discuss pregnancy and maternity discrimination which occurs at the workplace. In fact, that is something that can occur at the public place, shop floors, restaurants. But I was looking at just the workplace. So I was looking at the Equality Act section 18, not section 17. So if you want to visit our page, you can obviously, these recordings are always on the platform. So if you find it, if you miss any part of it, the employment law that I discussed last week, if you missed any part of it, you can visit the show or the platform again. If you find it very tantalizing and insightful and educative, you can share it with your friends. So you always find them there as well. We specialize in family law, and I always say that we are not just solicitor of solicitor firm. We are family law accredited. There was a distinction between a solicitor and a family law accredited solicitor. And so you can always get the best from city law solicitor because we are family law accredited. So if you have any family law matter you want us to assist you with, you can always get the best from us. If you had a problem having contact with your child or your children, we can assist you with child arrangement order. If you have suffered domestic abuse and you want a non-molestation order or occupation order, we will be able to support you to make that application. If you are, on the other hand, defending non-molestation order or occupation order application, you are forewarned because this is a criminal offense. I said it here last time that I personally dealt with the case and the other party is now in prison. So these days, this Domestic Abuse Act makes it a criminal offense. So the perpetrator can sometimes receive custodial sentence. So people should be careful whenever they are defending some of these cases. They should not take it lightly. If you need legal advice, proper legal advice, you can come to City Law Solicitors. They will be here to assist you so that you don't end up in prison. Good evening, caller. Right. I think he couldn't stay on. Right. So I'm saying going ahead. So that's about the family law. If you are going through divorce and you need us to assist you in terms of the division of the matrimonial assets, whether some of them are being hidden in Ghana, in Nigeria, in Kosovo, we will be able to ensure that we can avoid or help you not for your spouse not to dissipate the assets. We'll make sure that we'll bring all into the matrimonial pot so that you can have your fair share. Personal injury and clinical negligence. If you have had accident at the workplace that is not your fault, we can assist you to get some compensation. If you are involved in motor accidents and you have had some injuries, we can also assist you to get some compensation. Commercial dispute and civil litigation. If somebody have taken some money from you or in the name of providing a service and has failed to do that, we'll be able to pursue that person to get your money back for you. So don't allow that person to take your money. Under our civil litigation department, we'll be able to assist you to deal with that. Housing law, if you're having housing disrepair problem, if you're being evicted and you want us to defend you, again, we can also do that. Consumer law, which is what I normally come to discuss here, I enjoy it so much because it affects all of us. So if you have any matter along those areas, we can also assist you. So guys, It's been a privilege to have all of you here tonight. Before I go, I want to quickly acknowledge those who joined us late. We have Gifty Abla Nyaze, who is also watching tonight. William Opoku watching. Kobana Amamkwa, who have just joined us. Thank you so much for joining us. Senior Ajay, who is watching us tonight. Che, Kwesi Che, Deborah, who is also watching. I have Justice Peace, whom I have already acknowledged. So guys, thank you so much for joining us tonight. On Thursday, we are going to have the same program, the same topic. But this time, MC Chaka will host the show, wherein we will take the opportunity to discuss everything I have discussed here tonight in Chi. So it's an opportunity for our brothers in the diaspora, our family in the diaspora, to enjoy free legal advice in the Chi language. So please, on Thursday from 9 o'clock or 9:30 onwards, kindly join us so that we can have the Chi section. I want to thank all of you who have joined us tonight, and God richly bless all of you for being part of this community, the community that brings liberty to you. Thank you so much, and God bless you. God bless you.